Good evening and welcome to RFL. I am Richard French. Now, we're just 19 days from Election Day, and more than 17 million Americans, they've already voted. Imagine that. Now, for the sake of comparison, at this point 4 years ago, fewer than 1.5 million people had cast their ballots. Also today, the Senate wrapping up its confirmation hearings for Judge Amy Coney-Barrett. Now, the next step, it's a vote in the Senate Judiciary Committee, which is set for a week from today. That puts a full Senate vote on track for before Election Day, and her confirmation at this point all but assured. Today, each side made its closing arguments. Let's start off with the Democrats.
I believe that this rush sham process is a disservice to our committee. She has been rushed in a way that is historically unprecedented. There's never been a nomination in an election year after the month of July, and the purpose of doing it is simply to have a justice on the Supreme Court, as the President said, to decide the election and to strike down the Affordable Care Act.
The President himself has been making it very clear why he wants this justice on the court. He said he wants 9 people after the election. He says that he wants a court that's going to overturn Obamacare. He has made all of this clear. You have the fact that because of what this President has been saying, it undermines this process, undermines the court, and that is why we should delay.
I think she makes a compelling argument. Ain't going to happen, though. Here's the other side. Republicans with their closing arguments.
I'm really struggling to find out and to understand why Judge Barrett is such a threat to them. Is it because they've become accustomed that when they lose elections and they lose votes in the Congress, they depend on the courts to bail them out? That's not what judges should be doing.
Certainly there is nothing about this nominee that can be left as suggesting that she's anything other than an extraordinarily gifted jurist, is well prepared for her service on the federal judiciary in a different capacity instead of being on the Seventh Circuit on the Supreme Court of the United States. The fact that she won't commit to certain controversial policy positions makes her more qualified for the job, not less.
All right, now let's go back to the Democrats and something that Senator Sheldon Whitehouse highlighted during the hearings. Rhode Island Democrat, he outlined a conservative feedback loop where groups like the Federalist Society are funded by dark money that they then use to run PR campaigns lobbying for nominees that match their litmus tests. Once they get those judges that they want, they then identify key cases and back people on their side of these issues. Then they'll file briefs. They'll actually write the briefs here designed to lead the judges they helped put on the court to the decisions that they want. I'll let the senator take it from here.
This is to me, pretty big deal. I've never seen this around any court that I've ever been involved with, where there's this much dark money and this much influence being used. Here's how the Washington Post summed it up. This is a conservative activist behind-the-scenes campaign to remake the nation's courts, and it's a $250 million dark money operation. $250 million is a lot of money to spend if you're not getting anything for it. So that raises the question, what are they getting for it? Well, I showed the slide earlier on the Affordable Care Act and on Obergefell and on Roe versus Wade. That's where they lost. But with another judge, that could change. That's where the contest is. That's where the Republican Party platform tells us to look at how they want judges to rule, to reverse Roe, to reverse the Obamacare cases, and to reverse Obergefell and take away gay marriage. That is their stated objective and plan. Why not take them at their word?
So that's the cultural seismic changes that could be before the court. But let's do a little math here. Before I bring in my guest, I wanted to show you what Delaware Senator Chris Coons had to say yesterday. And I think he does a really good job describing the scope of the issues the high court could impact.
On the board behind me, I've asked my team if we would just go back and look at cases All of these cases listed, it's roughly 120, have something in common. Justice Ginsburg was in the majority. Justice Scalia was in the minority dissenting. And these are cases that touch on nearly every aspect of modern American life. I've talked a lot yesterday about health care and the Affordable Care Act. Yes, that's on there. A number of my colleagues have talked about some other areas. But what's striking is if you just look at what a 5-4 balance towards this methodology means if changed towards a 5-4 balance to this methodology, it has huge consequences for education, for consumer rights, for access to the courts, for civil rights, for immigration, for environmental protection, for Native American rights, for workers' rights, for elections, for executive power, for reproductive rights, for free speech, civil justice, economic development, privacy, government misconduct, prisoner rights, capital punishment, gun safety, and criminal justice.
I can't think of a better person to bring in now for this conversation. Dahlia Lithwick. She's a senior editor at Slate Magazine. She's also a Supreme Court reporter. And for my money, she covers the court as well as anybody. Dahlia, I want to go over as to what we learned, but also what we didn't learn, and then also the stakes with the Barrett seemingly inevitable confirmation. First, though, I want to share with our audience some of the questions posed to Ms. Barrett and the non-answers and what that actually tells us.
Does the Constitution give the President of the United States the authority to unilaterally delay a general election under any circumstances? Does federal law?
Well, Senator, if that question ever came before me, I would need to hear arguments from the litigants and read briefs and consult with my law clerks and talk to my colleagues and go through the opinion writing process.
Is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts.
Do you think that the president has the power to pardon himself for any past or future crimes he may have committed against the United States of America?
Well, Senator Booker, that would be a legal question. That would be a constitutional question. And so in keeping with my obligation not to give hints, previews, or forecasts of how I would resolve the case, that's not one that I can answer.
Dahlia, I get the strategy. I don't even, even falter for being as evasive as possible. There's no upside to being transparent. But some of these basic questions about core election law, among other things, are written already into the Constitution. These don't need to be litigated. Am I right to be concerned that I can't even get the basic minimum that we're going to have a free and fair election, and that is our constitutional right from this possible, if not future, justice?
Richard, this is exactly the stuff that really sent up a flare for me. This is separate from I can't comment on, Roe v. Wade, or I can't comment on some specific case that's on the docket this year. This is actually being asked just basic, as you say, constitutional principles. This is, in some sense, saying that because Donald Trump threatens lawless, unconstitutional action, instead of saying that is lawless and unconstitutional, and a first-year law student knows it's lawless and unconstitutional, she purports to be open-minded in case it comes before her. And it really, I think, in addition to, as you're implying, destabilizing confidence in just basic constitutional norms, to have a life-tenured federal judge say maybe absentee ballots are, going to be tossed, and that's an open question, so I can't opine. I would be very, very nervous if I was trying to vote by mail today, hearing that that's somehow now an unsettled question.
And by the way, on the idea of changing the election date, this is not some theory that has to be poured over in briefs, et cetera. The Constitution prescribes that strictly to Congress, and Congress alone can do this. This is settled law. Again, if you take the president as his word, he believes that this election will be decided by the Supreme Court. These aren't my words, the president's own words. She has shown no indication that she would recuse herself if there was any election-related cases that went before the High Court. Again, take me out of it, take you out of it. Wouldn't any fair reading of where recusal should actually belong would be Exhibit A, given what the president has said about the prerequisites for her nomination in his view? Shouldn't she have to recuse herself if some election case went before the court?
Well, she doesn't have to do anything, as she was quick to point out. The question is there an appearance that something is really hinky here? And again, I agree with you. After you've had Donald Trump say time and time and time again, the reason we're rushing this person onto the Supreme Court is so she can vote for me in a closely contested electoral question that comes before the court. He's said it explicitly. That's why she has to be there. Then that raises, I think, for an awful lot of people, the appearance of bias, the appearance of impropriety. Judge Barrett's answer to that when she was pressed was, I don't think I did anything improper. Nobody asked me to throw the election to Donald Trump. Why are you impugning my integrity? Without understanding that it's not a subjective test. It has nothing to do with what she has promised to do or what she's going to do. It has to do with the public's confidence in a fair judiciary.
You know, we showed our audience part of what Senator Coons had to say yesterday, and I think he put it in numbers the public can get their arms around. 120 cases, decided 5-4, and how a new makeup of the court could radically change things. I want to just play, this was from the White House lawn at Judge Barrett's introduction by the president. This is how she views her legal viewpoint and specifically references Justice Scalia.
His judicial philosophy is mine too. A judge must apply the law as written. Judges are not policymakers, and they must be resolute in setting aside any policy views they might hold.
So, Dahlia, a lot of people heard the term originalism today. Can you explain, as an originalist, how she approaches cases and why, for those who think, oh, it's just one more justice, to Senator Coons' point, if she follows, and she's given every indication that Justice Scalia is the model at which she'd most emulate, how she could radically change so many givens that the public just assume or foregone legal assumptions?
Well, theoretically, originalism means that when you go to look at the Constitution, you say, what was the original public meaning that the drafters had in mind? On the critique of originalism, I think there is, the problem that time has changed and we can't be bound by the views of the framers. We also can't agree on what those views were. But I think there is a larger problem, which is that the framers themselves left deliberately open-ended language in the Constitution. So when they talk about equal protection, when they talk about due process, when they talk about cruel and unusual punishment, they deliberately left those broad and expansive so that future generations could pour in contemporaneous meaning. Her argument is, if the framers didn't say anything about nonviolent felons being barred from having guns, then it's not in the Constitution. And Senator Durbin was very quick to point out that the framers were thinking about muskets, not weapons of war. And so to try to lash us to the thinking about guns at the time of the framing is to totally misunderstand the lethality of guns today.
You know, Dahlia, a lot was made of super precedent, and Judge Barrett made a point that Brown versus Board, for example, she believes is a super precedent. The argument being that there's really no more debate in this country about a separate but equal in the classes. But she wouldn't extend that to same-sex marriage. She wouldn't accept that certainly to the Affordable Care Act, Roe v. Wade, to name a few. It seems to me pretty subjective what is settled and what isn't. And if I look at the polls, 2/3, 3/4 of the current population, and even in greater numbers for the coming generations, believe in these actual changes that we've had in our social compact. I'm going to talk next segment to one of the key folks attached to the Obergefell case. Should the public look at this new made court, assuming she's confirmed, and say, okay, well, they're going to continue to chip away at some of these rights? Or are they underestimating just how seismic, if some of these cases come back, that Roe could go away completely? same-sex marriage could be, wiped away in a single ruling. How do you view how we should expect in the coming years the court, what cases they'll take and how they'll rule on them?
Richard, there's only one sitting justice on the current Supreme Court that doesn't believe in precedent, and that is Clarence Thomas. Even Justice Scalia famously said, look, I'm an originalist, I'm not a nut. And the nut was referencing Clarence Thomas, who has long taken the position that if a case was wrongly decided, it doesn't matter if we've relied on it for 200 years, it's garbage, we should do away with it. Amy Coney Barrett is the next person that will be on the court who has openly said and written in law review articles, she just doesn't think judges should be bound by precedent. And that's why what seemed like this very fanciful theoretical conversation about what is super precedent, which means it can't be disturbed, is really alarming for the reasons you laid out. She wouldn't commit that Obergefell was super precedent. She wouldn't commit that Roe was super precedent, or Casey or Griswold. And what that means is she's signaling these are open to negotiation. And I think you're right. That is exactly as seismic as you suggest.
And I think, just for myself, where I didn't really take seriously this court packing conversation even a week ago, I could see where it could gain a lot of traction in a new Congress, depending on how this election goes. Okay, finally, Dahlia, last question. A little inside baseball, but Senator Whitehouse laid out a loop that I know you know about, and people who follow the court as closely as you do. But I guarantee you the general public hadn't really heard much of this yet. And it goes something along the following, that you have hidden donors, obviously with Citizens United, pouring a ton of money into picking who they want to promote as conservative judges. The same group then spends a ton of money for PR to back the nominee. The same groups with the same money identify the cases they want to go to the high court, and those same people actually write the briefs that they want heard. For anybody who thinks this is some giant conspiracy theory, I'd say on your own time do some homework here. But again, this morning he pledged that he's going to spend a lot of time in Capitol to try and bring this to light. This has been an untold story that really the genesis is where we find ourselves today with Judge Barrett, but obviously before her, the Gorsuches and the rest.
Yeah, it's one of the things that was maddening for me as a viewer, is that even in-house at Slate on our editorial channel, people were saying, what is he even talking about? And you're quite right. I think most people thought this was some weird Homeland stringboard conspiracy theory, but it's all been amply illustrated. It's been well reported. And he's absolutely right to say that some donor, we don't know who, because dark money, paid millions of dollars to the Federalist Society and then laundered it through their dark money channels to block Merrick Garland from having a vote, then again to support Neil Gorsuch, Brett Kavanaugh, and that this is all happening. These perfectly transactional court packing efforts are happening as these same groups are bringing litigation, like Citizens United, like the case he described yesterday that dismantled public financing for unions. So he's trying to say something that I think was kind of tossed off by opponents as this is just some crazy conspiracy theory. It's not a conspiracy theory. It is, in fact, how this has worked. It's why we're about to get another Federalist Society approved judge seated on the court. And
again, what Dahlia just said, I couldn't amplify more, and this is not theoretical anymore. We're seeing this play out in real time. Dahlia Lithwick, great conversation. I appreciate the time as always. Thank you.
Thank you. Take care.
Up next, the LGBTQ community already alarmed by Amy Coney Barrett's views and how she refuses to answer basic questions about things like same-sex marriage. After the break, we're going to show you how some of the basic rights of that community could really be in jeopardy after she joins the court.